Let us pray. Lord, our governor, bless the leaders. Prime Minister, all the members of the obligation, nation, grace to your Father, teach our people to rely on you. Thy kingdom come, thy will be done on earth as it is in heaven. We forgive those that lead us not.
This House is in session. Minutes of the meeting held on Tuesday, 28th of March, 2023, Friday, 31st of March, 2023, Tuesday, the 2nd of May, 2023, and Tuesday, the 9th of May, 2023, to be confirmed. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be confirmed.
Question that the aforementioned minutes be confirmed. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned minutes are hereby confirmed.
Messages from her.
Minutes of the meeting held on Tuesday, 16th May 2023 to be deferred. Honourable Leader, Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
Questions that the aforementioned minutes be deferred. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned minutes are hereby deferred.
Messages from Her Excellency the President. Petitions, papers.
Honourable Leader, Government Business.
I'm commanded to lay the annual report and audited financial statements of the Fair Trading Commission for the period April 1st, 2020 to March 31st, 2021.
Government notices, private members' notices, notices of questions, reports from select committees, first reading of bills, statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honourable Leader, Government Business.
Mr. Speaker, I beg to move the suspension of standing orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
Questions that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business, sir.
Government Business is the order of the day.
Order number 7, in the name of the Honourable Minister of People Empowerment and Elder Affairs, to resume the debate on the second reading of the Child Protection Bill 2023.
Honourable Member for St. Michael South.
Thank you very much, Mr. Speaker, sir. I want to again thank the House for allowing me this opportunity, sir, to speak on this bill and to conclude and to send this bill off to select committee. But it's quite fortuitous, sir, that we have the opportunity to come back and to address some of the things that I've heard during the course of the last week and to reinforce the main points of this piece of legislation that is before this House, sir. Let me begin again by reminding the House and the public, sir, that the legislation that currently serves as the primary legislation in relation to child protection is extremely old and outdated. So last week I went through great pains to explain, sir, that this legislation was, for the most part, sir, written 100 years ago. Some of it in 1918, some in 1904. Sir, I took that opportunity, sir, to suggest very strongly and clearly that our society then, compared to our society now, sir, is a completely different society. And that indeed what that legislation was meant to address in 1904 and 1918, and some of it, sir, the more recent ones in 1983, 85, do not reflect the current circumstances of the day. Sir, I took that opportunity. So the first thing was in relation to the age of the legislation. Sir, I also took that opportunity to explain that this Convention of the Rights of the Child, that Barbados ratified the convention because now there is talk that this administration is somehow now making some unholy alliance with powers that be to subject ourselves to the will of an international community like mindless, unthinking people and be subject to the dictates of this in the international community while we are passive recipients of that dictate. And I made the point, sir, very clearly that the Convention on the Rights of the Child was not signed by anybody in this House. Period. Whether they're here in person or not, sir, that the Convention on the Rights of the Child was ratified by the government of Barbados, not by this Barbados Labour Party administration or any Labour Party administration. But indeed, the Convention on the Rights of the Child was ratified in 1990, when the Democratic Labour Party was in office. It is interesting to me that the very same Democratic Labour Party is now criticizing the very same Convention on the Rights of the Child that they ratified, not this Barbados Labour Party administration. It is a kind of a contradiction and a hypocrisy, sir, but unfortunately it is also a short-sightedness, because there is really nothing inherent in the convention that is dangerous. But men now have set themselves their sights, sir, solely on achieving political office by criticizing anything that falls in their way, even themselves, sir, to gain political office. And that they who criticize should ask themselves who ratified the convention in 1990, and to state their objection to their own party's ratification. And to criticize, in many cases, sir, the founding fathers of their own party, because it was their party, sir, who ratified the convention. None of us in here did, sir. And I call it a short-sightedness only because, sir, so set are they on achieving office that the benefits embedded in the Convention of the Rights of the Child, they're now ignoring. They're now ignoring, sir. So now to suggest that we somehow are only responding to some international community is an error, an unfortunate error, probably a deliberate error, because I know that this bunch of Democratic Labour Party candidates and hopeful MPs in some distant future, sir, I know that they have no regard for the former Democratic Labour Party. And so I suspect that when they criticize the ratification of the convention, that they're deliberately criticizing the stalwarts of the Democratic Labour Party. It is an attack by this bunch of DLP supporters and candidates on the former Democratic Labour Party. That's all it could be, because the Labour Party wasn't involved in it at all. it is obviously a case, sir, of infighting. And so I would wish for them, for they who criticize the ratification of the convention, to come out and to say what about it they criticize. And if they are so opposed to it, to come out and say who they are opposed to, because none of us in this place ratified it. But again, sir, I want to make the point, sir, that it is short-sightedness, because there are things in the convention, sir, that speak to the protection of children, sir. This convention has been ratified by several countries, signed by several countries, further ratified by several countries. So it is not a thing that Barbados has done on its own. And I looked at the file, sir, as I was preparing for my presentation last week. I went through the file, sir. I saw different persons responsible for children, different ministers responsible for children, making comments on the file. I've seen no objection to it at any point in the file, sir. And what this Barbados Civil Party administration has done is different. There is an OECS model bill, and I feel I have to take the time to explain this morning, sir. I won't be long. But there is an OECS model bill that has now shaped this emergence of proper child protection legislation in the region. We took that OECS model bill. We dismantled it, sir. We have a belief in this party, sir, that when it comes to these things, sir, you have to go through them word by word, line by line. We dismantled it, sir, deconstructed, reconstructed, our jargon, and made sure that that legislation, sir, was fit for Barbadian purpose. We went through it line by line and made sure it was fit for Barbadian purpose. We then held several consultations with other persons in Barbados, sir, including the very same people who know that they have on political blinkers, now have now taken a dislike for the same legislation that they were endorsing previously. Same people who had the opportunity to comment on the legislation and endorse the legislation, now that they're wearing their political blinkers, sir, have lost all sight and all direction. And I will speak to that perhaps in a little bit more detail further. So I want to be clear, so that we consulted far and wide, so that what you see before you is a piece of legislation, sir, that reflects the Barbadian reality. So one, the legislation that guides the current principles in Barbados, sir, that guides the relationship in relation to children is old. And two, sir, it was signed in 1990, not by this administration or any Barbados Civil Party administration. And three, we consulted heavily, including some of the same people who are now criticizing the legislation. 3 points. I go further, sir, because these things must be said. There are people now who are suggesting that this legislation takes away the rights of parents. That this legislation, because we are articulating that you have to give a voice to young people, children should have a say in their own issues, that this legislation somehow takes away the rights of parents. Nothing could be further from the truth. So I took the time, sir, and I went through the existing legislation, the different pieces of legislation, sir, because point 4 is that the current legislation is a patchwork. You want to do something with children, you have to go to the prevention of cruelty to children, the protection of children. I mean, there are all kinds of pieces, sir, of legislation all over the place that you have to be able to address. We pull it all together. But when you go through these 4 or 5 different pieces of legislation, you can find very few references even to the word parent. In the existing legislation, not the one that I am bringing, or the Honourable Minister responsible for Home Affairs, when you look at what exists now, there are very few protections set into that legislation for parents. And I say, sir, in this floor of Parliament, without fear of contradiction, that our legislation now has more protection for parents than any other piece of legislation that referred to children in this country, for sure. For sure. But there is now a narrative, obviously, meant to achieve, again, political ends, suggesting that we have somehow taken away the rights of parents. Sir, I have worked at the Child Care Board. I do not stand here because of some political affiliation. We both worked at the Child Care Board. So we know, sir, that at the end of the day, what exists and what does not exist. I don't need anybody who skimmed through legislation to come and tell me about how it works. Somebody who has never had a single relationship with children in this country to come and tell me how this thing works, sir. I know for a fact that parents now have way more protection. The need to consult in this legislation begins at the very beginning, sir, and goes all the way through to the end, from the cradle to the grave consultation with the parents, sir. To the extent, sir, that we are even now allowing the officers to go to the households and work with parents. This legislation and the one that follows, sir, you would see at all points the whole intention is to keep the family together. That is the point. To keep the family together. The family is the priority of the legislation, sir. So we're working to protect children within the context of protecting and maintaining families. You pull any of the existing bills, sir, you will not see it. So for those who have a lot to say, that we are taking away the rights, I encourage them, in fact, I challenge them to pull the legislation that currently exists. Show me the rights of parents in that legislation. To pull this legislation and to show me where we have taken away any single right of parents in this legislation. And I go further, sir, when they fail at it, because they will fail at it because it is a lie and conjecture. When they fail at it, I will then show them all of the things we put in to protect parents in this legislation. Or not, the former Prime Minister, sir, the MP for St. Peter, used to say to all of us that you cannot take the low road to high office. And time after time, it is clear to me that the Democratic Labour Party candidates, sir, are keen on taking the low road every single time. Last election, sir, I was happy to see new candidates come forward. Because I am still relatively young, I was happy to see new candidates come forward. This time around, I am happy to see new faces come forward. Happy to see that young people want to get involved in the political process. But there is a toxicity somehow now that permeates George Street, that whoever comes forward seems to take on this personality, that their politics must be the politics of lies and conjecture. And I will go further, sir, because it is clear to me that even at the risk of the reputation of this country, even at the risk of hurting the very children that this legislation seeks to protect, that those who come forward will go to all lengths, sir, to try to get political office, sir, even if it means that it destroys the same children that they're trying to protect, sir. There's a person who is now on today's front page as a professional. She's a professional by day and a politician by night. I don't know if she speaks, sir, in a professional capacity or if she's speaking in her political capacity, but I know this, that when I look at what is being said, sir, by this person, and in yesterday's paper, sir, I read what it was. I thought for a second I was misreading. Sir, it is suggested, sir, in yesterday's news, Daily Nation, sir. And you have to read these things, sir, because, you know, there is a great danger in letting some of these things pass. The rights of the child should not be given to the state. This is the title of the article, sir. And in this article, sir, it is quoted, sir, permit me to say, sir, because this is what the article says. Parents are the voices of the children, not the state, says human rights activists, and it goes on to name the person. This article then goes on to say, sir, all kinds of things, sir, and I won't even address all of them, but this last paragraph really had me concerned. This paragraph, sir, says...
I don't remember, you know,
I know the rules.
Yes, and that if it is not a document of the House, and I can understand the enthusiasm and the pain that it is causing you, Honourable Member, but don't quote.
Sir, I would not quote, sir. There was a suggestion made. And that suggestion, sir, was that in this legislation somehow, that we have not only taken away the rights of parents, but that somehow all of the state's authority now will override any authority of the parents. It goes on to say, the suggestion, sir, becomes further ludicrous by saying that we will now allow children to have medical procedures. That we will now allow children to have medical procedures that could come back to hurt the children. I do not know where this came from. There is no reference to it at all in any of the legislation. There is no reference, sir, this is somebody, sir, speaking on a political platform by night, being a professional the next day, giving the impression that they have no political persuasion, but we know that this is politics. Taking on a political personality under the pretext of professionalism, bringing into question now a whole profession, suggesting that this legislation would somehow allow children to have a medical procedure that they will later regret in life. There is no reference anywhere at all in this legislation to anything such, sir. So I would like to know where that came from and what was the injury that this person was trying to cause, sir. And that it is causing fear and panic deliberately, sir, to drive people away from an administration that is doing what is in the best interest of children. It is a very, very dangerous thing, sir. And I say it all the time. I said, sir, that I was very happy to see new persons emerge. And I support them. But I just do not understand why in the attempt to gain political office, people will lower themselves to these levels. And I would like to think sometimes, sir, you know, even as I try to think that a political party could come somehow and publicly sanctify itself, and that my expectations, sir, might have been too harsh, but every action they do live down to my expectations. Every action living down to my expectations, sir. I listened, sir, to the bits and pieces that I heard. There is nothing in this legislation that speaks about any medical procedure, any child being allowed to go to a doctor and having a medical procedure that would somehow, the child will somehow regret. A kind of conjecture and innuendo meant only to cause pain, sir. Meant to embarrass the country, meant to scare children, sir. I do not understand how all of us, whether we are in this place or another place, can agree that children should have a say in their own business, that children should be allowed to actively participate in the decision-making processes that govern their lives, all of us, anybody of mature thinking. But yet when you offer them the opportunity in legislation to participate in the decision-making processes that would govern their lives, particularly for the most vulnerable children. Particularly for the most vulnerable children. We are somehow suggesting, sir, that we are violating the rights of parents, sir. That, sir, is innuendo, lie, and conjecture, sir. It is my understanding, sir, on this whole idea, sir, because, Mr. Speaker, sir, I believe that the truth has got to be spoken. I do not know, sir, of any Labour Party person, sir, whether it is in this administration or this legislation or otherwise, sir, would come and suggest, sir, as was the case, sir, by a former member of Parliament on the other side, a sitting minister at some point, would come and suggest, sir, that 16-year-old children should get the HPV vaccination with no reference to their parents, sir. A former member of the outgoing last administration, sir. That was not this Barbados Labour Party. There is no reference in anything that we do, sir, to making parents lose that authority. sir. So when the conjecture and the lies are spoken about the Barbados Labour Party, sir, you know I have a saying that stop telling lies on me, or I will tell the truth on you. And the truth is, sir, that it was a member of the Democratic Labour Party that suggested an HPV vaccination should be given to children without reference to their parents. It wasn't me, sir. I do believe, sir, that there's a need for consultation on a lot of these things. I do believe, sir, that parents have a right to be heard. And until we address the legislation, sir, because, sir, in all fairness, there is a problem currently in the legislation. I explained it last week, sir. I'm sure you are familiar with it. That at 16 years old in Barbados, that is the age of consent. That means that a child at 16 years old can consent to sexual relations in Barbados. However, until you are 18 years old, you cannot go to a doctor without your parent. So obviously, sir, you can engage in activity without your parent, but to go to the doctor for 2 years, you need to have a parent, sir. There's a conversation that needs to be had. And it is immature. It is immature and it is dangerous to try to lay blame to some evil at the foot of the Barbados Labour Party, sir, when this Barbados Labour Party is the administration that is trying to do right by children, sir. I will close, sir, because I will have another time to speak. And I know the Honourable Member for Christchurch East, the Honourable Minister of Home Affairs, will have an opportunity, sir, to address a number of these issues. So I would close by saying, sir, that this legislation serves to protect children. This legislation, sir, serves to protect parents. I throw out my challenge one more time. Show me in the legislation, in the former legislation, the pieces of legislation where we have taken away the authority of parents. And show me in this legislation, sir, any gaps, sir, and those are the ones that we must now seek to fill. Sir, the last point that I wish to make is that we are sending this bill to Select Committee. And in Select Committee, sir, we would allow for persons to come in and to make representation. The reason that we are sending the bill to Select Committee is to allow for other views to contend. And to have a piece of legislation that has been subject to so much rigor that when in its final iteration, sir, it reflects, therefore, the will of the country. So there are some suggestions, sir, that I have heard, sir, that I've been discussing with the Honourable Attorney General, sir, that perhaps we need to look at some things, make the legislation where we felt that it was clearly, sir, to some people we need to make it clear, and in Select Committee, we will make it as clear as possible. There is no, in law, sir, I'm not a lawyer, but I know that you can raise a bill. Most of these bills, sir, like the Domestic Violence Act, sir, mostly are dealing in the civil realm, but that the criminal charges come under another bill. Well, this is not new, sir. So I do not understand why all of a sudden, sir, it's like, oh, these things are not here. If we need to make amendments, sir, we will make the necessary amendments. That is why we are sending the bill to Select Committee. And I encourage persons, sir, who have an objection, sir, persons who have an opinion, and persons who feel they have something to offer, to come forward and to make a contribution. And from the floor, we give the assurance that those things would be heard, sir. And where they, sir, align with what we are trying to do, sir, where they add value to what we have doing, where they, sir, put in the things that we may have left out, because no administration, sir, no drafting is perfect. I've been in a room the other day, sir, with 4 lawyers. 4 lawyers. And all 4 had a different opinion on the same piece of legislation. This is a fact. All 4 had a different opinion on the same piece of legislation. That is the norm, but it is the beauty of the legal process. It is the beauty of the legal process, that it allows people to have an opinion, sir, and to make a defense of it. But to run on the court. And the other thing is this, sir, as I close, sir, before I send this bill to Select Committee, sir. While I think the opposition is being intellectually dishonest in all regards, because I've just explained to you where this thing started. It didn't start with us. I've explained, sir, that the parents, sir, are protecting this legislation. While I think they're being intellectually dishonest, sir, I feel that there are those, sir, who have the public's ear, who also have a responsibility, sir, to engage in a little bit of rigor and not just to repeat what it is that is being said by politicians for political purposes under the pretext that they're professionals. Any person in the media, sir, or any other person, sir, could pick up the legislation, go through it, and see that a lot of the claims that are being made, sir, are untrue. And I encourage them so to do. I've also, sir, said to my staff yesterday in a staff meeting, because if I speak, they will think it's political. Y'all are free, according to the permanent secretary, not from me. The permanent secretary said the heads are free to go and speak about the legislation. Because the legislation, sir, is written, sir, in a way that the public servants feel proud about it, sir. So there is no underhand business going on in this legislation, no attempt, sir, to sabotage anybody. And I just wanted, sir, to take this opportunity to make those things clear. There are a few other points, sir, but that is an opportunity for another time, sir. So with those few words, I beg to move this bill will be read a second time.
Honourable, the microphone.
Mr. Speaker, sir, I beg to move this bill be referred to the Joint Standing Committee on Social Sector and Environment.
Questions that the bill be sent to Select Committee. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Order number 8, sir. In the name of the Honourable Minister of Home Affairs and Information, to move the second reading of the Child Justice Bill 2023.
Honourable member for Christchurch East.
Mr. Speaker, I thank you. It is very difficult coming behind the impassioned and passionate and heartfelt presentation by my colleague from St. Michael South. It is such passion, sir, that was displayed through this entire process as we worked together to harmonize the child protection legislation and the child justice legislation. I saw a side of him, sir, that having read some of his poetry, I knew that he had, but often he camouflages his softer side, sir, with political bravado. But he could not camouflage it with something as near and dear to his heart as child protection. And I know one of his children, sir. One of his children actually lives in my constituency. And they say you shouldn't judge a parent by the child. Usually they say that when the child has done something bad. But I think, sir, that he'd be happy to be judged by his child because she's a wonderful young lady who thinks he's the best father in the world. Sir, where are we and why are we here? If we live in Barbados, sir, and we cannot ignore the circumstances increasingly facing our children, we would have grown up, sir, at different stages with the challenges appropriate for the times in which we live. Back in the day, sir, my mother's only concern, or her concern, was I got home before the street lights came on. She didn't cast her mind any further than that. When we went to the beach in summer, sir, we left in the morning. I just had to get back home before the street lights came on. At that point in time, your parents started to worry, not before. A child, sir, the most a parent would shout at you, tell you, look, go outside and run about, and stop playing video games because video games had just come in. And the legislation, sir, that might have governed us as children, both in terms of our protection and in terms of our justice, would have been appropriate for the times in which we live. By our time, sir, my time was a little bit behind yours, but by my time, sir, the legislation was becoming outdated. So you know, if it was outdated some 40 years ago, then it is woefully outdated now. We are brought face to face with the realities of what our children are facing. We read of the problems that our children are encountering. Often, some people say that we've deviated from old, hardcore Bajan values, that our children are subject to too many outside influences, that they don't know right from wrong. I think, sir, it is simply the effluxion and evolution of time. Every generation has to deal with new challenges, and the rules that govern us in society must be constantly reviewed to make sure that they're appropriate for the challenges being faced by that generation and to govern society and prevent anarchy. Sir, what is clear from the suite of legislation, and by suite of legislation, sir, I will refer to the child protection legislation, the child justice legislation, and the soon-to-be amendments to the educational system, sir. If you have sight of all of these pieces of legislation, it is clear, one thing is patently clear, that children are at the center of it, the well-being and the protection of our children. In the wider outside circle, sir, is the retention of the family. So all of these pieces of legislation, sir, tend to steer us toward protecting and guiding our children, and also as much as possible keeping the family unit intact, whether it be by direct intervention with the children or whether it be with direct intervention in relation to the family unit. This child justice bill, sir, was on the card, but let me not say this. A child justice bill was on the cards when the last government was in. It was not brought to this parliament for reasons best known to them, though I understand that some form or fashion of it was floating around and knocking around on the desks of those responsible for well over 2 to 3 years. But it did not come before this parliament. We took the position, sir, back then, in 2018, that focus on our children and modernizing our legislation was a critical thing for us. When my honourable colleague for St. James North, sir, occupied the seat that I now hold in cabinet, he pulled that legislation, dusted it off, looked at it, decided it was woefully inadequate, and went back to consultation on it because things had moved on. And we were intent on getting the best possible draft of the legislation as we can. As with our whole legislative process, we're not looking at stopgap legislation. If we're looking to revolutionize an area, sir, we strip it down, we deconstruct it, reconstruct it, and make sure that at the time our legislation is passed, it is cutting edge. It is the most modern piece of that type of legislation in the world at that time. And I wish to thank my colleague from St. James North, Mr. Edmund Hinkson, who started this process and gave me a platform on which to back with the runs already scoring. There was a lot of work, and he also remained an accessible and willing resource for me with questions that I had and my ability to consult with him to get us to the point where we are now. I also wish to commend the honourable member for St. Thomas, who occupied the position previously held by the honourable member for St. Michael South. And she worked tirelessly to push both pieces of legislation. Quite frankly, sir, the child justice legislation was ready in some form well before the child protection legislation. But we also had to look at the signal that we wanted to send. With what was happening with our children, did we want to send the signal that this government was more important on dealing with them once they got into the system? Or was it equally or more important to keep them out of the system? Thus, it was decided, sir, that we should run the preparation of the child justice legislation and the child protection legislation side by side on a parallel course. That had an additional benefit. The additional benefit was that it allowed, anytime an amendment was made in one, to make sure that that amendment harmonized with what was happening in the other, so that when we come to the end of it, although the two touch and concern different topics, they are necessarily related, because as you will see when I get into mine, a process started under the child justice legislation can be diverted, and the child continue under the child protection legislation where the circumstances so warrant. So they had to be harmonized and harmonious. And we went through a long process. As the Honourable Member for St. Michael's South just said, we consulted with everybody. Everybody who had an interest had a seat at the table. All of the persons that you know who are accustomed speaking on this topic had a seat at the table. All the organizations who you know have representative interests in this subject matter had a seat at the table. And we embraced all because it was important to us that when completed, this legislation was our own. It was owned by all of us, not just this Barbados Labour Party government, but also the traditional opposition party, also the fringe parties, also all of the stakeholder organizations, also the man on the street. It was intended that everybody looking at this would have had a chance to play a part or have their voices heard in relation to it. We didn't want to drop something. I mean, children concern us all. The family unit necessarily is contemplated to include a child. So every family in Barbados contemplates or contemplated a child in it. So everyone should have had the opportunity to weigh in on this because it affects us all and it affects the younger generation who will grow up to be decision makers in this country as well. So when we approach the last election, in the manifesto, sir, for 2022, under the justice system, it was clearly said, sir, that there will be emphasis on juvenile justice legislation. Sir, also, there was a recommitment to our position on restorative justice. As outlined in the 2018, I can make this a document, House, sir. I believe it already is. As outlined in the 2018 manifesto, alternatives to the fine and confine approach were established. The BLP will build future altering interventions, whether it be coding classes in prison, after-school music classes, etc. But there was the commitment to restorative justice. And restorative justice as well, sir, plays an important part in the juvenile justice legislation, the child justice legislation. So the Barbados Labour Party is a front runner in this. It was under the former Attorney General, Sir David Simmons, that the Penal Reform Act was framed and sought to transform the system of justice in Barbados. What we perceive justice to be, what were the imperatives of justice, what were the focuses on sentencing, whether it be rehabilitation, with a heavy emphasis on rehabilitation, and trying to put our persons who had to be away from their families for a while in the best possible position to go back in and become constructive members of our society. That was started, sir, way back in the 1990s administration of the Barbados Labour Party. What we're doing here, sir, is having wasted some good 10 years between 2008 and 2018 on it, we are now trying to bring it to its fruition. We're trying to bring it before the people of Barbados as a living, breathing document, which they will have a further ability to input into. Sir, how is it different? How is this new legislation different? This bill, sir, is intended to bridge the policy gaps and capture the legislative and institutional amendments necessary to provide a holistic approach to the rights of the child, sir. And this bill will make or does make provision for the reform of two pieces of legislation that have recently occupied the attention of the public: the Juvenile Offenders Act, Cap 138, and the Reformatory and Industrial Schools Act, Cap 169. Sir, we seek here to establish a modernized approach to handling children who are in conflict with the law, and that is the phrase that we choose to use rather than juvenile offenders or whatnot, which carries a certain stigma on it. We try to, in our wording and in our structure, emphasize the positive outlooks that we're trying to make and try to stay away from stigmatizing our children. So we're trying to establish a modernized approach to dealing with children who are in conflict with the law by establishing, sir, a system of assessment to ensure the child is properly assessed by a court in proportion to the offense committed. We establish a diversion mechanism. All of these I'll go into further, but I just want to state them up front, which enables the court to remove the cases of children who are in conflict with the law from formal court proceedings. It's also incumbent to ensure that children who require care and protection, which can better be dealt with under the Child Protection Act, are diverted to proceedings under the Child Protection Act. We also look at different forms of sentencing, sir. So community-based sentencing, restorative justice sentences, and corrective supervision. There also is provision for the operation of secure residential facilities for the detention of children who have committed serious offenses, the establishment of a reintegration board to facilitate the early release of a child from a secure residential facility. So I'll just pause here for 1 second. This government is perhaps the government that has most sought to divest itself of authoritarianism where it could, of absolute authority. The Prime Minister, our Prime Minister, sir, is perhaps the Prime Minister who has most shed things within her discretion to make it more palatable and transparent. So under the existing legislation, the person who got to decide whether a child had to stay the full term or go home early was the minister, in the sole discretion of the minister. The minister does retain a discretion under this new legislation, sir, but in addition, there's a reintegration board, and the name says what the objective of that board is. At the earliest possible time, to be able to reintegrate the child into its family, back into society, back into school, so that the child can continue to be a productive member of society. And this bill, sir, also seeks to involve parents and the community in the processes by way of family group conferences. Now, I will deal with that separately. Sir, let's start first with the application and criminal responsibility. This act has said that a child under the age of 12 is not capable of committing a criminal offense. Under the previous legislation, so under the Juvenile Offenders Act, Cap 138, Section 8, right, said that the court shall not render punishable for any offense a child who is not, in the opinion of the court, above the age of 11 years and of sufficient capacity to commit a crime. We know, sir, what that has led to. The ambiguity in the language has led to situations where it is sought to establish that the child, although under 11, had a requisite mental capacity to be able to commit a crime. And for those who are listening, a crime has two components. There's the actus reus, which is the act, the offending act, which under the legislation constitutes a crime. But you must also have the mens rea, or the mental ability or intention to commit a crime. So if you accidentally do something and a crime results, but you were not negligent in doing it, then the court will likely find that you had no mental component to establish a crime. So although the action happened, the crime was not committed because there was no mental element there. So this posed some issues, sir, when arguing as to what really is the appropriate age for criminal responsibility, and is it an absolute age? Is it an age based solely on a number? Is it an age based on a combination of a number and maturity? Is it an age based on a combination of a number, maturity, and IQ? And this has led to some interesting results in the courts. Sir, this legislation has changed that. Clause 5, early up, sir, Clause 5. A child under the age of 12 years is not capable of committing a criminal offense. There's no ambiguity there. There's no wiggle room, there's no leeway. Under 12 years old, that child is not deemed to have the mental capacity to commit a criminal offense. Sir, it also looks, sir, at the general guidance as to how a child should be treated in the context of the juvenile system, taking into consideration the safety, welfare, well-being of the child, his beliefs, and the rights of the parents. And part 3 of it deals with the assessment of a child. Now, this is a brand new and critical addition to the legislation, sir. As it stands now, sir, a child or someone convicted of an offense or charged with an offense gets to have their circumstances considered after they are found guilty at the stage of mitigation. So when you go through the entire process, then if the person is found guilty, there's special circumstances that are considered then to assist in what the appropriate sentence should actually be. Under the new legislation, sir, when the police officer brings in or takes custody of the child, before anything else, that child is supposed to be assessed by a probation officer. Before anything else. So I'll give you the comparison between the old legislation and the new legislation. Under Section 992 of the Juvenile Offenders Act, the language is before deciding how to deal with him, this is after a finding of guilty, the court shall obtain such information as his general conduct, home surroundings, school record, and medical history as may enable it to deal with the case in the best interest of the child or young person, and may put to him any question arising out of such information. Now understand, sir, once again, this is after a finding of guilt. The new parallel clause, Clause 7.4, the police officer responsible for the investigation of a case with respect to a child apprehended in accordance with subsection 1 shall ensure that the child is assessed by a probation officer before the commencement of the initial inquiry into the offense alleged to have been committed by the child. Before you start to question that child has to be assessed. Even after questioning occurs, if the child is charged or brought before the court, the magistrate or presiding officer has access to the initial assessment. So before the evidence is taken in respect of the child, the magistrate is fully aware of the circumstances of the child that he's dealing with. This is not a child in abstract. When young Arthur Holder comes before me having committed some offense, sorry, sir, I will respect the sanctity of the seat. Sir, when young Kurt Humphrey comes before me having committed some greater offense, I know who Kurt Humphrey is. I know where he came from. I know how he's doing at school. I know what his intellectual level is. I know if he's been in other difficulties, because that then allows me to make other decisions and informed choices that ensure the best treatment for Kurt. Young Kurt, based on what I know, may not be served by going through a judicial process. Young Kurt might be better served by diversion. Or young Kurt might be coming from a family where the behavior of the family is such that Kurt has to go and steal to feed himself. At which point we should not be looking at finding Kurt or charging Kurt or trying Kurt for theft or shoplifting. But instead we should put him in a protective environment where Kurt gets the food that he needs. So this is a revolutionary approach to justice. Sir, under Clause 13 of the previous Act, no young person shall be sentenced to imprisonment if he can be suitably dealt with in any other way, whether by probation, fine, corporal punishment, committal to reformatory or industrial school, or otherwise. Compare that, sir, with the new section, the new parallel section, or comparable section, which is 59.2. A sentence of imprisonment shall be used as a sentence of last resort, and that sentence shall not be imposed unless the child is of the age of 14 years or older at the time of commission of the offense. So we start by saying it is a last resort. Imprisonment of the child is a last resort. Now, sir, under the previous legislation, the age in which you consider the possibility of imprisonment, I believe, was 10 years. But this one is now moved into 14. Sir, if we look at the Reformatory Schools Act, other provisions in relation to the children and how they are secured and dealt with, it says at 11.1, wherever any child who in the judgment of the court or magistrate before whom he is charged is under the age of 16 years old is convicted on indictment or in a summary manner of an offense punishable with imprisonment, in lieu of or in addition to any other punishment which he may be subject, the court or magistrate may subject to Section 2, sentence him to school and there detain for a period of not less than 3 years and not more than 5 years, but not in any case extending beyond the time when the boy is in the opinion of the magistrate to attain the age of 19 years. Sir, the point was made by someone yesterday. Sir, that the old legislation treated the juvenile in a worse way than adults. Juveniles got the short end of the stick. So where there was an offense, sir, that was punishable by imprisonment, where imprisonment was an option, I need to be real clear on this. Where imprisonment was an option, and an adult, so where for an adult it would have said a fine or imprisonment, for a child, fine was gone and imprisonment occurred. And that imprisonment, sir, had to be between 3 to 5 years, a minimum of 3 years. Any child awarded a custodial sentence by the court went up for a minimum of 3 years. There was no 6 months and let's review. All of the options, sir, that existed to adults and were available to adults to deal with them, to evaluate them, to consider them, to suspend a sentence, to whatever, all of those options or none of those options apply to children. If you were found guilty of an offense that could attract imprisonment, you went up for 3 to 5 years. So let's take the wandering that people don't like to talk about. Well, everybody likes to talk about. A girl who was found guilty of wandering went up for mandatory 3 years. There was no provision to assess her situation after 6 months, a year. She's shown exemplary discipline. She's shown exemplary progress academically. Let us give her a chance on the outside. And this applies to boys too. Any boy attracting a sentence that was punishable by imprisonment went up for 3 years. And our aim and the trend of modern legislation is to invoke judicial discretion. Is to promote judicial discretion, especially in terms of sentencing. And we talk about about mandatory minimum sentences, and people question the constitutionality of mandatory minimum sentences. Sir, we had them existing in our legislation in relation to children, and no one questioned it. So we have now done away with that. Sir, it goes further to state, so in relation to corporal punishment, I know this is a hot one for people. So under section clause 59.5, corporal punishment, severe or frightening measures shall not be inflicted on a child detained in the prison under the section. And in relation to those in a secure residential facility, section 87.1, corporal punishment, severe or frightening measures shall not be inflicted on a child in a secure residential facility. Now, sir, what does that mean? Not just the corporal punishment or whipping, as some of the legislation has it, but you can't even threaten to do it. You cannot punish a child in a way that is severe or frightening to that child. The child must understand the reason for which they're being punished, and the punishments for the most part, sir, are also set out in the new legislation. But what is clear is that corporal punishment is now completely removed as an option in relation to children under our penal system and under any realm of sentencing in relation to a child, no matter what the offense. Sir, I pause here to switch a little bit and let's talk about the initial inquiry and diversion. I think perhaps the signal policy enshrined in this legislation is diversion. The ability to divert. What does that mean? I hear no one ask. As it stands now, sir, if a child comes into conflict with the law and is picked up by the police, that child is questioned. If an offense is found to have been committed, that child is then charged and tried pretty much in the same way that you would try an adult. The child goes through the prosecution, the lawyer may make a no-case submission. If not, they continue to defense. They go the whole way through. And at the end of it, if the child, as I said, is found guilty of something punishable by imprisonment, that child can be sent up into custody for 3 to 5 years. That's as it stands now. We have introduced something now, sir, called diversion. Diversion, I think there's a definition for it, sir. 1 second, sir. It is so important, I actually want to read the definition of diversion, sir. Diversion means the removal of cases of children alleged to have committed an offense from the formal court procedures and the adoption of informal procedures in relation to such children, pursuant to Part 5. And a diversion option means a plan or program with a specified content and duration set out in 3 levels under Section 36. Now, what will now happen is that a child who is picked up by the police for being in conflict with the law gets their initial assessment. The police then will do their investigation, but that child, during the course of that investigation, has to be attended by a social worker, a parent, and they have the right to an attorney. So this is not even a legal aid discretionary thing now, sir. The law actually says that the child has a right at every stage to be represented by an attorney paid for by the government. So we may have to reshape the legal aid framework, because this, as I said, this is not discretionary. Any child, of course, you can't force anybody to accept legal assistance, but any child who wishes to avail themselves, or any parent who wishes to have their child avail themselves of legal representation is free to do so, whatever the offense, at the expense of the state. And there are certain rules in relation to the attorneys as well who deal with the children, that they have to explain to the child in language they can understand, that their foremost duty is to the child, while they can encourage the child to take responsibility for their actions. They should not pressure the child, etc., etc. right? So it's child-centered, but you go back to diversion. So the investigation is carried out, and a charge is brought. When that child first appears before the magistrate, as I said, would have seen the assessment form. If the magistrate has not yet seen the assessment form, the proceedings are halted until the assessment is done and the magistrate has cited the assessment. At that point in time, sir, the magistrate can use his discretion and say, you know what? Based on what I see here, no justice is going to be served. Send this child through a formal court process. Maybe it is better that we engage some other form of resolution in relation to the child. Maybe it is better that we engage the child protective services to deal with the child and can divert the child at that point in time. If it doesn't occur there and the court starts to hear the proceedings in relation to the child, at any point in time in those proceedings prior to the close of the prosecution case, the magistrate can halt the proceedings and recommend diversion or make a diversion order in respect of the case. And the lawyers representing the children are also encouraged to be able to push for the diversion orders. What does the diversion order do? The diversion order says, you don't have to go through these formal proceedings. Let's have an evaluation on you. Maybe an apology might be sufficient. Maybe an apology and counseling might be sufficient. And there are levels of the diversion. I will go into them later, sir, but the basic thing is that if the matter is so diverted and the child satisfies the terms of the diversion order and complies with and receives a favorable report from the probation officer, then that's the end of the matter. Then the child has no conviction against him and is not in danger of going anywhere and can go home to his family. And there's family counseling involved in here as well, sir. Sir, proceedings in the court are also conducted in an informal manner, sir, to encourage maximum participation between the child and his parents or an appropriate adult in a manner that can be understood by a child. So the legal jargon is out of place. The court proceedings in relation to the child are conducted in language suitable for a child to understand. The attorney, and they're informal, so you can get interjections in there, you can get clarifications in there. The magistrate can ask the child, do you understand what was said? Ask the child, would you like to explain it in your own words just so I can understand, so I'm certain that you understand what is going on. So the whole proceedings are child-friendly. And as I said, the court may divert the matter anytime before the closing of the case for the prosecution. So if we get to a point of a guilty, pre-sentencing reports and pre-sentencing conference is mandatory before the court can sentence. So the court cannot impose a custodial sentence unless a pre-sentencing report has been received and considered by the court. But even so, and that's under section 50 and 51 of the new bill. Even so, sir, the pre-sentencing conference includes the probation officer, it includes the representative of the child, and it can include the child as well. So there is no unilateral decision-making in respect of the sentencing for the children. At all points in time, the child's interests are there to be represented so that the final outcome, no matter what it is one that has had the child at the center and all options in relation to the child having been considered. Sir, the other thing, another important diversion, sir, or addition, is the use of the family group conference. Now, this does not appear anywhere in any legislation that we have previously had. Nowhere at all does it appear. And it is deemed to be a part of the restorative justice agenda, sir. So At paragraph 54, at clause 54, which is under restorative justice sentences, where a court makes a determination of guilt with respect to a child, the court may refer the matter to a family group conference for a written recommendation. And who are in the family group conferences, sir? The following persons shall attend a family group conference: the child and parent of the child or an appropriate adult. Because let's be honest, sometimes with the children who are in conflict with the law, the parents have no interest in the child at all and don't appear. So if we kept referring to the parent of the child, then half of the important aspects of the legislation will be hamstrung if you don't have cooperative parents. So the court can also appoint an appropriate adult, or an appropriate adult can also be recommended by the probation department. So every time you see parent or guardian, then an appropriate adult is there to act in loco parentis if none can be found. So the following person should attend a family group conference: the child and parent of the child or an appropriate adult. Any person reasonably requested by the child. So the child can actually say, you know what, I trust Uncle Wilfred. He's my godfather. I want him to be there. My good godfather. The probation officer, a police officer, importantly, sir, the victim of the alleged offense which the child committed, and where the victim is under 18 years, the parent of the victim or an appropriate adult on behalf of the victim. The attorney at law representing the child where applicable. A member of the community in which the child resides, recommended by the probation officer, and any person authorized by the probation officer to attend the family group conference. So there's no limit. And what you're seeing now, sir, is community involvement in the process. So we are not looking at the child in abstract. A priest from the area in which the child is, where the child goes to church, or who knows the child, can say, look, let me help. I want to help. A Sunday school teacher, a neighbor, you always got them people in the gap who look out for the children in the gap. That person can be called to attend, a mentor, right, can be called to attend a family group conference. And the aim of this family group conference is restorative justice. It is meant to bridge the gap between the victim of the offense and the child in conflict with the law. So this is ADR, sir, alternative dispute resolution at its best. This is perhaps the most progressive thing that we have done in relation, no offense to my friend from St. Michael South, but this is perhaps the most progressive thing that we have done in relation to resolving issues or disputes with children. Now, there's a procedure that you have to follow, sir, and the family group conference is encouraged to try to resolve it, try to make an award that restores the injured party, right? Usually an apology is involved, all that sort of thing, sir. But if for some reason the family group conference cannot bring a resolution to this, then the matter is referred back to the court. I think they have 14 days, or they have a time limit to deal with it. But then the matter is referred back to the court, which will proceed with its sentencing. Now, sir, another important thing is under section clause 63, notice the parent of child. And that clause, importantly, says, people keep saying, I find a lot of parents, sir, have abdicated responsibility for their children. They let the children leave home, the children behave as they will, and the parents take no responsibility. When children damage some things, sir, the parents ain't want to hear that. They were not there. They ain't tell the child to do it. They ain't got nothing to do with that. So the victim who can't enforce for damages against a child is left without a remedy. Sir, not anymore. Under section 63, where it appears to the court that finds a child guilty of an offense relating to the property or against the person of another, on evidence admitted or on submissions made in the case against the child, the willful failure on the part of a parent of the child or an appropriate adult to exercise proper care of or supervision over the child was likely to have substantially contributed to the commission of the offense, and B, that compensation may be paid to any person for loss caused to the person's property, whether the loss was an element of the offense charged or happened in the course of commission of the offense, or injury suffered to the person, whether as a victim of the offense or otherwise, because of the commission of the offense. So effectively, the court can give notice to the parents that you may be held liable, and the parents then have to appear. And when I say parent, I mean parent, anybody who has custody of the child, has to appear to show cause why it should not be levied against them. The other thing here, sir, is in relation to children, quite often the offenses don't necessarily combine all of the elements of an offense for an adult. So even where damage occurs, like a child, I don't know, runs through your house swinging a bat, right? And then runs out in the road and somebody swerves and to miss the child and crashes into a pole, right? So, but then it follows, the causal, what is a normally or naturally inferred consequence of the action, falls to be compensated by the parent. So where a parent has been delinquent, they're not monitoring the child, they should have known better, their poor exercise of control over their children, or their negligence in respect of that child has resulted in damage to the property of another or to the person of another, then that parent can be called upon to pay the damages. And if they don't pay the damages, sir, then you know the normal causes in relation to contempt of court and imprisonment then follow. So, for all who feel that being a parent is you beget a child and that's the end of that, no. You need to participate in your child's upbringing. You need to participate in supervising your child. You need to monitor what your child is doing. You need to pay attention to the child's behavior because you may be held responsible for it. There was some concern, sir, under the former legislation in respect of something that happened maybe 2 years ago, sir, where a parent was concerned that they may not have been notified that their child was moved for treatment from a secure residential facility or from the government industrial school. We have sought to address that and codify that, sir, by section 79(5) that says where a child is moved from a secure residential facility to a hospital facility, psychiatric facility, or residential protection and treatment center for examination or treatment, the child is not discharged from custody, and during the time the child is hospitalized, the child should be deemed to be in the custody of the director of the secure residential facility in which the child was detained before hospitalization or treatment. But it also said, sir, that notwithstanding subsection 3, that they remain in the custody of the director, no child who is hospitalized in a psychiatric facility should be discharged from this facility except in accordance with the provision of the Mental Health Act, and the director shall notify the parent of the child or an appropriate adult and the director of child protection where a child is moved from a secure residential facility to a hospital, a psychiatric facility, or residential protection and treatment center for examination or treatment. So no moving of people's children without their consent or information. And as I said, sir, we account for the fact that sometimes the parents are unreachable. So if the parent shall be notified as soon as possible, sir, and in addition, the director of child protection. So the child cannot leave a facility without somebody in the protective services knowing and understanding where that child is and what treatment that child is being afforded at any point in time. Sir, we have here, sir, perhaps the most revolutionary piece of legislation that we have brought so far. And it is child-centered. Although the child protection legislation, which was dealt with by my colleague before, deals with the protection of the child and the embracing of the child, and this legislation is normally contemplated to be the punitive aspect of the suite of legislation. This piece of legislation at all stages also protects and secures the interests of the child. So I perhaps should have started with this, but I take you to the principles enshrined in paragraph 6.1 of this legislation because they properly encapsulate exactly what guided the legislation, sir. The court or person performing any function pursuant to the provisions of this Act shall be guided by the following principles. The safety, welfare, and well-being of the child shall be the paramount consideration. Codified is in the law. The safety, this is number one, guiding principle number one. The safety, welfare, and well-being of the child shall be the paramount consideration. B, a child shall, as far as possible, be given an opportunity to respond before any decision is taken which affects the child. As I said, the proceedings are informed at every stage, sir. The child is represented, has the right to be represented by an attorney, and that attorney can intervene on behalf of the child at any stage in there. C, a child shall be addressed in a manner appropriate to his age, maturity, and intellectual development. D, a child shall be treated in a manner which takes into account his beliefs. This is all-embracing, sir. So persons of different religions, different spiritual backgrounds have the right to have their beliefs taken into consideration. All procedures carried out under this Act shall be conducted and completed in a timely manner. F, the parents and family, can I have some water, please? The parents and families of a child shall have the right to assist the child in proceedings under this Act, and wherever possible to participate in decisions affecting the child. So this legislation does not keep parents on the outside. Normally, sir, the players in the judicial process are the prosecutor, the accused, defense counsel, and the presiding officer, judicial officer, whether it be a magistrate or a judge. Right? Those are the players. In this legislation, we've bent and shaped the rules so as to recognize the frailties and vulnerabilities and the particular and peculiar circumstances of children, and allow them to be represented by the parents at every stage of the proceedings. All consequences arising from the commission of an offense by a child shall be proportionate to the circumstances of the child, the nature of the offense, and the interests of society. And this ties in with the restorative justice, this ties in with the diversion, this ties in with all of that, sir, that when you're dealing with a child, if it is a minor offense, then you deal with it in a way that encourages a resolution of a minor offense. If the child is poor and from humble backgrounds, then you deal with it in a way that accommodates the particular circumstances of that child. If, sir, to be honest, it is an archaic piece of legislation that is there because we just haven't cleaned it up off the books and it is of really no interest to society, then it is accorded the status of a no interest to society case. But it's proportionality. You look at the child themselves, you look at the nature of the offense, and you look at the interests of society, sir. And these are set out in the principles of the legislation. And a child shall not be treated more severely than an adult would have been in the same circumstances. So this, although we've taken away the mandatory 3 to 5, whatever the sentence for an adult is in relation to the offense, a child should never get a harsher penalty than an adult of the same circumstances would for the case. A child lacking in family support, education, or employment opportunities shall have equal access to available services. And I'll do H and I together. Every effort should be made to ensure the child receives equal treatment in relation to other children who have committed similar offenses. Sir, the bulk of the children who are in conflict with the law are the children of poor people, of poor Barbadians. Whether it is their circumstance, whether it is where they grew up, whether it's where they went to school, whether it's the influences that are in the gap near them, the reality is you don't see rich people's children in court. You don't see it. You hardly see middle-class people's children in court. If a middle-class child go and shoplift something, the parents can intervene real quick. Sir, shell out some dollars, and that charge disappears. Where a poor child goes and steals something, then the parents ain't got the money to make the approach. They don't have a name. They don't have a clout to call the supermarket manager and say, listen, that's my child. So the reality, no, let's be straight, sir. Let's be straight. Every time, sir, the public would not necessarily know because matters involving children are not reported in the press. But sir, we know having been in the court, every time you see a child in there for an offense, the child doesn't speak well, the child is not doing well in school, the mother, if they have to pay a fine, struggles to pay the fine, the circumstances are the same. So those children are disadvantaged by our system as it currently is. Poor people, children can't afford top lawyers. So I know you do some pro bono work, but sir, if some of those people that you represent had to pay your full fee, they couldn't do it. They couldn't do it. So what we have done in this legislation is no poor child is going to be disadvantaged because of the circumstances. They get access to everything. Everything that anybody else would be. You get access to a lawyer. You get access to a probation officer. You get access to a system that is now shaped to protect you and encourage your diversion out of the system. Normally, sir, we try as fast as possible to get to the end of a case. Right? When you have somebody who poor can't defend themselves, the worst thing, sir, is some people who choose to defend themselves. You know the prosecution runs through them cases. Just get the end of sentence. Just get to the end of sentence. The aim of this legislation is not get to the end of sentence. The aim of this legislation is divert wherever possible. How else can we deal with this other than convicting a child, a poor black boy or girl? Sir, that was the guiding principle of the legislation. When making a decision regarding the release of a child in detention, sir, because you get to consider at the first hearing, you get to consider during the process, and even at the end, sir, a court shall consider the following principles when making a decision regarding the release of a child in detention. Preference shall be given to the release of a child into the care of a parent or an appropriate adult with or without the imposition of conditions. My friend just now, not an hour ago, sir, he spoke about the preservation of the family unit. And we're doing more than anybody else, sir, to try to keep that unit intact and encourage rehabilitation and reintegration. At every step in this process, we're trying to get the child out of the system. And even, sir, in considering whether to release the child, the first consideration is not releasing the child to the child care board. Is not releasing the child into a protective environment. The first consideration and preference, the use is the word preference. The preferred option for the court in dealing with children is to send that child back home and let that child come to court where necessary. So where the release of a child into the care of a parent or appropriate adult is not feasible, the release of a child on bail or bond upon the recommendation of the prosecutor shall be considered. So sometimes you don't want to put that child back with the parents because the initial assessment might have pointed to the fact that the parents are largely to do with the behavior or neglect of the parents are largely to do with the child being there in the first place. Then you consider putting that child on a bond, sir. And if the child is above a certain age, the child can be put on a bond of its own recognizance. And so where a child must be detained as a measure of last resort, I like the language, sir, that's being used. They're making it real clear. Preference, go home with your family. Where, as a last resort, the child has to be detained, the least restrictive form of detention appropriate to the child and the offense shall be selected. Whatever is the minimum that we can do to secure your attendance back in the court, we will. Whether it's by reference to child protection and put the child in a children's home, right? Whether it's by sending them, sir, whatever the least restrictive form, because that child must not feel that they are a criminal. The child must not feel that they're a criminal. Sir, it set out some of the rights of a child while in custody and whatnot. Sir, the one thing, I'm going to wrap up now, sir. But one of the critical things here is that we try to get the children to own up to what they've done. So the diversion, the family conference, all these things are usually contingent on a child owning up. So where from the assessment, the child has indicated the probation officer, the initial assessment, that I know I did it, then the magistrate sees that straight ahead and says, you know what, this child has accepted. All right, so we don't need to carry them through the rigor of a court system. How can we best deal with this child so that they can be reintegrated? At any point in the proceedings, sir, where the child indicates that they're willing to accept responsibility, that they're ready now to accept responsibility. Because, sir, sometimes we don't feel what we did is wrong. We might take a hard-ass position that, well, I wasn't wrong. But when you hear somebody saying it, and you understand from the victim that I've been hurt by this, it may filter through, sir, through the explanation of the probation officer, through the explanations of the attorney, through whoever. It may filter through, sir, that, you know what, I didn't do right, and I want to accept. And all the aspects of the diversion are contingent upon the child's willingness to accept responsibility for what they've done. The indication is, you know what, I accept responsibility. And then we look at what form that responsibility takes. Sir, I'm not going to look for the exact section and give it to you off the top of my head, sir. But some of the levels of punishment involve something as simple as an oral or written apology. If it's a fight between children, you cuff the child somebody too hard, then perhaps an oral or written apology might suffice. If the other person accepts it, then that's the end of that. The court may release you with or without supervision, or requiring you to come back. Sometimes it's something a bit more. Sometimes it is counseling. Sometimes it's a mandatory order that you have to attend school, that you have to attend certain counseling or classes, that you have to keep a clean slate, that you have no contact with. The normal things, sir, that usually attach to probation, right? Normally, if we think of what the probationary terms usually involve, then, sir, they run slightly along that, except they drift to the more lenient aspects of it. Let's not keep the child in the system any longer than the child has to be in the system. Sir, I am going to... It's a very long section, sir, but when we studied law back in the day, sir, there were two aspects of sentencing: punishment or deterrence. The penal reform system brought in rehabilitation. And at that time, that was seen as cutting edge. Punishment can be something other a sentence can be something other than punishment or deterrence. You looked at what was the appropriate punishment. Was it a slight one or a hard one? And you know what? What do I need to sentence you with to ensure you don't come back here again? So those are the two aspects. We then were cutting edge in the 90s, and we brought in rehabilitation. How do we rehabilitate this offender and let them go back, let them understand that what they did was wrong, let them understand they need to do better, and let them go back to becoming a productive member of society? That's what we got to in the 90s. Sir, we have gone way past that now, sir. We are now at restorative justice. We are at restitution. How do we make the victim whole as part of our sentence? If the victim becomes whole, then we do not need to imprison you or slap a conviction on you. If you apologize, although you found guilty, then we divert you or we deal with you another way. We look at reintegration. How can we reintegrate the offender? Give them the best possible chance of reintegration. And these are not things to infer from the legislation. Sir, they're built in and specifically stated in the legislation. They're built in. The protections are built in there. Sir, this legislation attempts to change what child justice looks like. We have, over the last 2 years, the child justice system has come for some heavy licks, sir, in the public, in the press, in social media. We've come for some heavy licks, and in some cases, deservedly so. Sir, there is a perception that any child getting into the system is going to be unfair. The child will come out worse than when it went into the system. Oh, Lord, don't get the police involved. If that child barely go to court, the child get it for 3 to 5 years. And the child can come out disgusting. So that is what the concept and perception of child justice is now. Child justice helps no one, including the child. You end up sentencing the child. The victim doesn't get any restitution or restoration. Nobody's benefited but the child. You lock away the problem and look back at it again in 3 to 5 years. That is what child justice looks like. No, sir. No, sir. The intention now is to change what child justice looks like for a child who comes into conflict with the law. Sir, we have to locate the debate in the entire transformation process with respect to our children. I am glad, sir, I am glad that I came right behind the Honourable Member for St. Michael's South, because it says to everyone, let us read these things together. They're yin and yang. They're two halves of a solution. We can't get away. It can never be only child protection, sir, because at some point in time, children will actually run afoul of the law and have to engage the judicial system. At some point in time, it will happen. As much as we may not want it, as much as we may not want to ever have to impose a custodial sentence on a child, at some point in time, we will have to. Let it be of last resort. But when it comes, let us ensure that the children who go into the system receive the best possible care and the best possible advantage in the system and come out better citizens. Thank you. Sir, and to this end, you realize that this legislation is putting a lot of burdens on the state. But the state has to do what it has to do. The system has to improve. Every person who comes in to contact with a child, whether under the child protection aspect or whether under the child justice ambit, every person coming into contact with a child has to be trained to deal with a child, not general social services, not general kind-heartedness. The officers who deal with the children should be trained in dealing with children. The probation officers who deal with the young children should be trained in dealing with young children. The social workers should be trained in dealing with children. The magistrates must get training in dealing with children. The court clerks, every person at every step has to have the training that enables this legislation and the child protection legislation to actually work, sir. And, sir, we need to deal with parental accountability. And as my almost parting shot, sir, I've been lucky, sir. I've been lucky. I've come up with people who cared about me, sir. And I've always had access to people who cared about me. I got some tough love back in the day. I think probably, sir, almost everybody in my gap beat me at some point in time. I used to give a lot of trouble as a child, sir. I'll be honest here. I wasn't easy as a child. And I was not abused as a child, but, sir, I accept that even when the tough love came, that the persons who administered it or who sought to take their time to correct me cared about me and wanted to see me do better. And we need to get back to that. Let us not turn a blind eye to what our children are doing. Let us not turn a blind eye to what our neighbors' children are doing. Let us not turn a blind eye to what our friends' children are doing. If you see children behaving bad on the road, do what I do. I immediately call the principal. I call them and get the principals, and I would take pictures of them. And I would tell the principal, some of your children are at this particular bus stop behaving in this way, or outside Cape Shepherd behaving in this way. Right? Sir, I love children. I love children. My heart is in this for children. This legislation is children-centered. I would not have it any other way. But as much as we need to get involved, sir, as much as we need to get involved, parents, the parents of Barbados need to get involved in the things that touch and concern their children. It cannot all be for teachers. Teachers have those children from 9 to 3? That's what, 6 hours? Teachers have children for 6 hours in a day, and not on weekends. You, the parents or the person in control of that child, have the child for all the rest. It is not for the teachers to instill the discipline that you refuse to introduce at home. You are responsible for, your child is a reflection of you. If you didn't want the child, you shouldn't have had the child in the first place. And if you cannot deal with the child and you cannot accommodate the child, sir, there are services provided by the government to assist in dealing with that, including counseling, sir. But what can no longer happen is that parents take their hands off, and when the worst happens to your child, you say woulda, coulda, shoulda. So, sir, the aim of the Child Justice Bill is to delineate the legislative and judicial measures to protect children as well as safeguard the rights of a child. It is envisaged, sir, that the children who become a part of the legal or criminal system at an early age would not be disadvantaged, but would be afforded opportunities to reverse their situation. This bill, sir, seeks to ensure that the time spent in a secure residential facility and by participating in programs and interventions, these children and youth will reintegrate into communities equipped with emotional intelligence, self-worth, and aptitude to become successful and productive adults. I repeat that. We seek to ensure that after time spent in a secure residential facility and participating in the programs put on, and by the interventions provided by this legislation and the child protection legislation, these children and youth will reintegrate into the communities equipped with emotional intelligence, self-worth, and aptitude to become successful and productive adults. But, sir, I caution you, the ultimate success and administration of both the Child Justice Bill, sir, and the Child Protection Bill that was recently introduced into Parliament will only be achieved and maintained if appropriate interventions and programs are designed and executed both at organizational and community levels, and I say at the family level as well. We all must work together. We all must work together and ensure that our youth are not ostracized, but they can be afforded opportunities within mainstream society to be in a position to reach their fullest potential and contribute not only to the development of themselves and their loved ones, but to Barbados. Sir, having gone through and over this bill more times than I can count, having consulted with more persons than I can count on the bill, sir, I am also satisfied, and this is, I didn't want to have to go here, but sir, I'll go here. Sir, this bill, I am assured, ensures compliance, sir, with the UN Convention on the Rights of the Child, Universal Declaration of Human Rights, United Nations Standard Minimum Rules for the Administration of Juvenile Justice, which we call the Beijing Rules, the UN Rules for the Protection of Juveniles Deprived of their Liberty, and the UN Guidelines for the Prevention of Juvenile Delinquency, the RIDA Guidelines. We own this bill. This is our bill. This is this government's bill. This government's bill is part of a suite of legislation aimed at protecting our children from cradle to adulthood. We have ensured compliance with our treaty obligations, sir. But we didn't do it because of that. We did it because it was time, and it was right, and it was just, and it was the best that we could do, sir, to ensure the protection of the children of Barbados within our justice system. Sir, with those few words, I beg that this bill be read a second time. Sir, I
Honourable
beg that this
questions,
bill be sent to committee, sir, for further consideration.
Questions that this bill be sent to committee for further consideration. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, we revert to messages from Her Excellency the President.
I am in receipt of your message from Her Excellency the President. Her Excellency the President, to the Honourable the House of Assembly. Her Excellency the President wishes to inform the Honourable the House of Assembly that on the recommendation of the Prime Minister, under Section 3, subsection 1 of the Ombudsman Act, Cap 80, she proposes to appoint Dr. Nigel Taylor, JP, SCM, to the office of the Ombudsman established by Section 2 of the said Act. Her Excellency further wishes to seek the approval of the Honourable the House of Assembly for the proposed appointment pursuant to Section 3, subsection 2 of the said Act. Signed, the President, State House, Barbados, 23rd May 2023. Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 1:45 p.m.
The question is that this honourable chamber be suspended until 1:45 p.m. All those honourable members in favour, please say aye. Those against, please say no. Methinks the ayes have it. This honourable chamber stands suspended until 1:45 p.m.